Hi, I'm Danielle G. Van Ness of DGVE Law in Hingham, Massachusetts. We help people with their wills, trusts, estates, and probate all over eastern Massachusetts and especially on Boston's South Shore. Tonight, I'd like to take an opportunity to explain the three primary ways that we can leave or receive an inheritance. There are obviously lots of different variations within these three, but it gives us a starting point, a framework to understand how we can start to structure our own estate plans. So the first way is by means of an outright distribution. I've taken to calling this the make good life choices, honey approach because I have teenagers. So essentially the idea is you say, here you go, this is for you, here's your inheritance, take it, do what you wish with it, and there are no parameters around it. The beneficiary can take that money, put it into a jointly held bank account, or start a business, or buy rounds for everyone, whatever he or she or they want to do with it. So that's option number one. Option number two is to leave the assets to the beneficiary in the form of a trust. So this is a trust for a beneficiary. And rather than giving the beneficiary all access to the assets within the trust immediately, we can kind of slow the beneficiary's role and stagger out distributions over time. So that might be in the form of distributions that the trustee is directed to make to the beneficiary. The most common example of this that we see is you, trustee, shall distribute to the beneficiary at perhaps a portion at age of 25, a portion at 30, and the rest of it by 35. Alternatively, the beneficiary might have the right to request to withdraw portions of the trust assets over time from the trustee. Or it might just be in the trustee's discretion to decide how and when to make those distributions and then have it all come out at once at a certain age. So basically, it's just kind of putting speed bumps in the way of the beneficiary so it doesn't all come out all at once. The third option is to leave it in trust for the beneficiary and just keep it there for the rest of the beneficiary's lifetime. So in that case, that lifetime trust will provide for the beneficiary. It might provide that the trustee says when and why and for what reasons the beneficiary can have the resources in the trust. That might be purely discretionary with the trustee in the trustee's sole discretion, or there might be some parameters around why the beneficiary should receive distributions of the trust assets. And a common example of that might be for general needs like health, education, maintenance, and support of the beneficiary. So depending on how the trust is drafted, the assets within the trust can provide for the beneficiary, but the key here is that the beneficiary never has the right to just plain withdraw all of the assets out of the trust, go put them somewhere else. For example, a jointly held bank account with a spouse or someone else, or maybe to just withdraw all the assets and start a business that might not work out, or have unfettered access and unrestricted right to all of the assets within the trust. So again, there are lots of different ways that you can have variations on any of these three primary options, but this is a good starting point. If you're in Massachusetts and you have questions about your will, trust, or overall estate plan, including healthcare directives and everything else that goes into that, I welcome you to contact us anytime at info@dgvelaw.com or on our phone at 781-740-0848, and you can find us all over social media at DGVE Law. We hope to hear from you soon.